Let's go on the record on cause number DC 1913360, David Jackson versus the Preston Tower Condominiums Association. Counsel, make your appearance.
Christina Alstron on behalf of the plaintiff, Your Honor.
David Johnson on behalf of Preston Tower Condominiums and ICI Management.
Helen Emerson, also on behalf of the defendants.
All right, we're hearing a motion for contempt, but I understand there's not a request for jail time. So normally if there's a request for jail time, then we probably would have this in person. Right. Anyway, go ahead and proceed.
Yeah, Your Honor, this is actually a motion for contempt and then a motion for supplemental protection because there's a previous protective order in place. Before we get to the substance of the motion to contempt and why we are seeking supplemental protection, let me provide a little bit of background on this case.
And just so you know, I have read everything, so
okay,
you don't need to go into a ton of detail, but
okay,
as I understand it, and is Mr. Jackson has started communicating directly with the defendant in violation of allegedly in violation of the motion for protection. Is that right?
Yes, Your Honor. And just, I prepared a little timeline, and if Your Honor will indulge me,
sure,
I can go through it just a little bit if I can figure out how to share my screen.
Yeah, I just enabled it so you can share your screen.
Very good. Okay. Do you see it, Judge?
Let me see. Yes.
Okay. So this case was filed in 2019. This is at its bones, this is a roof leak property damage case. Plaintiffs have also pled fraud, deceptive trade practices, misrepresentation, and a host of other things. Early on in the litigation, Mr. Jackson started communicating directly with my client, the tower, as well as the ICI, which is the management company for this complex. In December, he requested insurance policies and personal counsel for my client. Requested that all requests go through counsel. That had been communicated to his lawyers prior to that email. We went a few months. Then in March of 2020, he continued sending emails directly to the clients, requesting for documents and requesting various information. I've put snippets of these emails, Judge. These emails, most of them go 10, 15, 20 pages. They are long, rambling emails. My client again requested to Ms. Alstron to please have her client stop harassing us directly. And then he responded back to my client saying, perhaps providing these documents is beyond your scope of ability or brain power. This type of requests and these type of emails, and this is a fraction, literally there are hundreds and hundreds of emails that he has sent. In May of 2020, he started sending a string of document requests.
Wait, can I make sure I'm clear on something? Ms. Alstron, does she represent the plaintiff?
Yes, Your Honor.
Okay, I wasn't clear based on that one email. Okay, go ahead.
In May 2020, he started sending these string of mostly document requests, but other requests for information directly to the tower and ICI management. This one right here in May of 2020, 8 days in a row, he sent a long, detailed request for documents. Again, it was communicated that he needed to go through his counsel. In June of 2020, he sent a 10-page email to all the residents of Preston Tower. It is a very, very, very long email. This is only the very beginning of it, but this shows you just the attachments that he had on the email. Again, talking about this lawsuit, again, requesting information. We ended up substituting into this case in August of 2020. Prior counsel was the Bassett firm. They actually withdrew because of the emails that Mr. Jackson was sending, where he was sending emails directly to the Bassett firm, alleging conduct by them that they felt forced them out of the case. So we substituted in. We sent an email to Ms. Alstron saying, look, the communications need to come through you to us. He needs to stop harassing our clients, essentially.
But before you move on with this, let me ask a question here, and this is directed mostly to Ms. Alstron, but I guess to both sides, which is, given, I'm not assuming that these allegations are true, but if these allegations are true, it would seem like it would be important to have Mr. Jackson on this call. Is he there with you?
He is not, Your Honor. Given that given that the relief that they're asking for is really just essentially a revamping of the motion for protective order, and really that the contempt was not pursuing any, their motion for contempt wasn't really pursuing anything more than essentially a revised motion for protective order. I didn't feel it was necessary to have him on the call today.
So I guess my concern is, and I'm not fussing with you at all, I'm just a little concerned here, which is if he is violating these orders, and I think Mr. Johnson and Ms. Emerson are being very kind if they're not trying to put him in jail for that, because that is the remedy, or one of the remedies. How are we going to make sure that he complies with these new orders, if we have new orders, unless he kind of hears directly from the judge? Do you feel like he's going to listen to you if you kind of convey, hey, the judge did this or the judge did that, or would that not be helpful?
I think it would be helpful, but I think the other problem, and I don't want to sort of interject into Mr. Johnson's argument because I know he's not completely done. But I think the problem and the rub that we have here is that the communications that I understand that there's a pending litigation. And I understand that we have an agreed order previously that was an attempt to sort of come to an agreement with opposing counsel of how to direct the communication sort of through my office. But that order was limited to the extent he was making document requests. Mr. Jackson is still a dues paying member and a homeowner within the association, and he pays more than $1,000 a month in homeowners association dues. And the board is an elected board of officials that are there to serve the interest of the homeowners and those that are paying dues, as well as the management company is there for the sole purpose, or largely, to serve the requests of the homeowners, including requests for documents, maintenance requests, various other things. So we tried our best, and I think Mr. Johnson and Ms. Emerson would agree that we tried to best to craft an order that would sort of respect the fact that although Mr. Jackson is in litigation, he is still a homeowner, he is still a dues paying member, and he absolutely has the right to communicate with the board as well as the management company for things like maintenance requests, document requests, which are actually not only provided for in the declaration themselves and the bylaws that he's absolutely entitled to the inspection of the association's records, but it's also a requirement under the Texas Property Code. So I understand that there was some friction here, and I understand that Mr. Jackson does write and lengthy emails. But I also want to respect his First Amendment rights and also the rights that he continues to be a homeowner, and he's absolutely entitled to be informed as a homeowner. And just to put some context on this, again, he's paying $1,000 a month. He is on the penthouse floor, and the allegations in the lawsuit are that the roof has been leaking for more than 2 years now, damaging his unit. And he has, alleges $300,000 or $400,000 worth of damages, and he has been stuck, not able to repair it because he can't repair the interior of his unit if the roof itself isn't rectified. And just recently, October of 2020, the association commissioned a report, actually had someone come out and inspect the roof. And they put a very lengthy report together, did a thermal scan of the roof, and absolutely have established that the roof is completely failed and needs to be replaced at a cost of some $600,000 to the association, which will likely either be taxed against the homeowners by a special assessment or an increase in association dues. So sort of this is the context in which this occurs. So candidly, I think Mr. Jackson has a right to be a little upset over what's been going on over the past 2 years. And I am open for ideas as to how we can make it his communications more agreeable to everyone, but I also want to be very sensitive to the fact that it's my position that he's actually not violated the agreed protective order, and likewise he still has rights, and we need to respect those rights and his ability to communicate. And I think that's one of the things that's set out in their motion is, to the extent defendants are actually seeking to modify the protective order, they do acknowledge in there that Mr. Jackson would still be able to communicate with the association, especially with respect to repair requests. And I apologize, but I think there was one other item in there that would be essentially carved out. So there is going to continue to be communication. And like I said, I'm open for ideas of how we do this so that we are respectful of everyone and the amount of communications that they are getting.
Okay. I guess my main reason I asked that, and I feel like you just kind of gave your whole response, which is fine.
Sorry, I apologize.
Was really, would it be a good idea to have him on this call to make sure that he fully understands the ramifications of what's going on? But he doesn't have to be there. I was just
Your Honor, based on an email that he sent on Friday, and we're going to get to it, it's my understanding he's watching this on YouTube right now.
Oh, okay. That's fine.
So,
Okay.
I mean, that's what he said in his email that he sent directly to me on Friday, and we'll get to that. I don't disagree with a lot of what Ms. Alstron said. As far as the roof and the fact that there were leaks, there's no controverting the fact that he's had a series of leaks. And the association and the building has done its best to try to patch up that roof as best it can. But there's no question that there were leaks that went into his unit. The $300,000 of damages, we believe, is completely inflated. His initial estimate was less than $30,000 of damages. That's where the rubber meets the road on what the fight is between the parties, is how much are his alleged damages in this case. The problem that we have, and the problem that has been going on with Mr. Jackson, is that he refuses to, I think, listen to his own counsel, and I'm not fussing at his counsel at all. But he also defied the order of the court, and we tried real hard to craft an order that would give him the ability to communicate with the building if he had maintenance problems or things of that nature. The problem is he takes it and then he just pushes, and he goes over the edge. And let me show you just some examples of that. We sent an email to Ms. Alstron on 9/4/2020 asking her to tell her client to stop sending emails related to litigation to our clients. We didn't receive a response to her, but our client 2 days later did. He received, this is a 21-page settlement proposal email directly sent to, and we didn't attach the whole thing, but included in this settlement proposal that he sent to our client was a paragraph talking about my request to Ms. Alstron that he quit communicating directly with our clients. So he was aware, and his client and his attorneys were telling him, look, you need to stop communicating directly with the defendants in this case. We were then forced to file our motion for a protective order. The day before the hearing, Ms. Alstron called and said, hey, can we work out a remedy here to agree to an order? And we said we would. We crafted it. It's not just for document requests. That's not accurate. It also deals with any inquiries and any other discovery related to the claims asserted in this lawsuit. And here's the problem that we have, is that when Mr. Jackson sends emails to my clients asking questions about the roof, making demands on them about where he's alleging fraud in our lawsuit, where he's alleging deceptive practices in our lawsuit, and he's requesting all types of information. If that's discovery in and of itself, those emails, if my clients respond to him and to these inflammatory emails, and I'll get to some of those in a second, then they are in essence creating discovery as well. It's no different than interrogatories. It's no different than requests for admissions. It's no different than requests for production when he's requesting documents. So he's creating evidence by these emails that put my client into a box. So I have told my client, do not respond to these emails, because what these emails show, for example, no violations of court order. After the order was signed, there was nothing for about a month, a little over a month. Then he sent an email directly to the president of the board. The first paragraph of that email said, Christina, since Sean, the board, and ICI refused to honor their obligations, should we add this to our lawsuit as another cause of action against ICI and the board, which will buttress our claims already filed against them, that their actions on the roof are not an isolated instance, but in fact are a pattern of behavior of failure?
Oh, wait, who is that from and who is it to?
That is from David Jackson directly to my client a month and a week after Your Honor signed the order, saying that he shouldn't be sending these types of emails to the defendants. This goes to the lawsuit. It talks about the lawsuit. It talks about new claims in the lawsuit.
Yeah, that's clearly inappropriate.
So then the next week, he sends another email directly to Mr. Wolford about roof repairs. Again, the bones of this case is all about the roof. And he's talking about suggestions for the roof. When are you going to do this? I have given you several ideas for cutting costs, which you have rejected. Again, he's talking to my clients directly about an issue that is, it's an issue in this litigation. Again, that violates the court's order. Then the next week,
okay, so let me just say this. Is it a violation to question about the roof? I understand the litigation. I totally agree with you there, but I don't know that all of this is in violation, but okay, go ahead.
well, then the next week, though, he sends an email directly to me,
Which he should never do.
which he should never do. And it says, David, this email is sent because it appears my position has not been established. Then he states he never authorized his counsel to agree to the protective order. Says the first time he was aware of it was a couple of days ago. He proceeds, and again, I am not faulting Ms. Alstron or her firm in any way, but he proceeds to throw them under the bus multiple times in this email directly to me. We get down to the end, and he says, the protective order will be moot once my attorneys follow through with the commitment below. There's no need for me to have any, blah, blah, blah. It's time for my attorneys to start litigating this case aggressively based on your refusal to keep the case focused in your escalating I'm wrong thing, sorry. David, Chris, Christina, this is my position, so there is no misunderstanding. I will abide by that BS protective order that I do not agree with, so no further information is necessary on this after you have scheduled the motion for summary judgment, motion for contempt, for conceal of documents, et cetera, and the petition is amended to include suing the list of people he's provided.
So, Ms. Alstron, you have to understand that he can't place those types of conditions on obeying a court order. You don't get to say, I'll only obey a court order if the following things happen. He has to obey court orders.
I understand that, Your Honor, but I think we also need to look back to the language of the order itself, because I think that's important. Because I have looked at the language of the order, and I have looked at the emails that were cited by Mr. Johnson in support that he has violated the court order. And while, yes, there are some references to lawsuit, honestly, I don't think it violates
So I think you may be, I'm not being very clear here, which is he says, I will abide by that BS protective order that I do not agree with, so no further litigation on this. After you have scheduled the motion for summary judgment, motion for contempt, for conceal of documents, and the petition is amended to include suing, you can't put conditions on obeying a court order.
I understand that, Your Honor, and that's not the position we're taking, just to be clear.
That's the position he's taking here.
Well, I understand that he has stated that here, but that is not the position that we're taking, that we are not in violation of it, because our position is that he is not in violation of the court order because simply the communications that have been cited and referenced by counsel do not violate the express terms of the order itself.
Well, and Your Honor, if I can get to where we are today, and then I'll address
Go ahead, sorry.
No, we filed our motion for contempt and for supplemental protection. And I will tell you, just what Your Honor brought up at the beginning, when we filed this motion, and we talked to Ms. Alstron about it, I think Ms. Emerson had a discussion with her where we told her, look, we aren't trying to throw your client in jail for violating a court order. We believe he has violated this court order. Sorry, I froze for a sec. Let me unfreeze me. And then, there we go. We believe he has violated the order, but our biggest deal is we have a client who, like I said, this is a fraction of the emails that he is sending to our clients, a fraction. But then in this month, he sends another email directly to our clients. And it's addressed to Clayton Hearn, who's personal counsel for the clients, but he CCs our clients as well as his own attorneys. Talks again about the litigation. Talks about concealing of documents. There's nothing in going on about concealing of documents. We produced over 3,500 documents in this case. Again, he starts talking about the roof. Where are we on the roof? He's talking about his damages related to the roof. This is all about the lawsuit. And he's sending that directly to our client. But then most egregiously, and we were actually in pretty good place last week. Last Friday, the first email came at 5:40. He sent an email in response to our Preston Tower condominium, giving an update on where they were in addressing flooding, power outages. They were trying to figure out if their residents were even safe. He sends an email. I got a call that my storage area is flooded. Keep in mind, Mr. Jackson doesn't even live in this unit anymore. He's renting it out. Then he says, give me a list of the challenges you are referring to in your email. And he wants them to provide all this information, to stop what they're doing, provide all this information. Then he says, I don't know what dope the insurance company provided attorney, David Johnson, representing the interests of the insurance company and on a minor scale the association, is smoking in his pipe, but I have a right to this information contrary to any information he has relayed to you. This is going to my clients. Then we get another email 45 minutes later, accusing my clients of spying on him and stating that they have violated criminal statutes and that he is instructing his attorney to, quote, let the first rat that is willing to talk to my attorneys about who was involved off, both civilly and criminally, and threatening a 5-year prison sentence. Then 45 minutes or an hour and a half later, he sends a direct message to me, again, CCing his client or his attorneys and my clients. Starts Johnson, talks about a deposition we took where we referenced the 700 emails he sent to my clients. Goes on and on about various things in the litigation. Talks about this hearing, Judge, about this hearing. I look forward to you explaining your need for a protective order, which is a thinly veiled attempt by you and your law firm to try to make me look bad in front of the judge. Be sure to include this as an exhibit in your motion for protective order so the judge can see for himself how unscrupulous you, Hearn, the board of directors, and ICR management, et cetera, et cetera. I look forward to watching your attempt to pull the wool over Judge Hoffman's eyes. This is what we are dealing with, Judge, and this is a fraction of what is coming through from him.
Can I see the order again, just what the original order was? I think you had it up there earlier, but this.
And Your Honor, that's why we are not only seeking contempt, but again, we haven't really pressed on the contempt. We are more seeking, if this order isn't clear enough, we need another order that's much clearer as to his communications.
I don't know why this isn't clear. It seems pretty clear. It says restrict his document request, inspection requests, inquiries, and any other discovery related to his claims asserted in this lawsuit to those methods prescribed by the Texas Rules of Civil Procedure through his counsel of record and any other further order of the court. I think that's, I don't know what else we need. That seems, a lot of this stuff, Ms. Alstrin, that's being done is clearly in violation of that section.
Your Honor, a lot of the emails that, and I sort of put a chart together in my response. The emails, and here, if I can Let me
You want me to let you share screen?
Yeah, would you mind? Or is that Mr.
Yeah,
Mr.
let
Johnson?
me-
I don't want to cut you off.
No, no,
No,
no.
no, go ahead. We're running out of time anyway.
Okay. Um, let me.
Miss Rada, are you here for the 3 o'clock? Miss Rada,
I'm sorry, Your Honor, just trying to unmute. Yes, I am, sir.
do you still need a hearing or not?
It's actually not my motion. I'd have to defer to Mr. Vega on this one and to Mr. Lee.
Okay, well, just let us know if you still need a hearing, because this could go on for quite some time, but I need to figure out if I need to stop it, so.
Okay, I don't see the other counsel, so I guess I'm the first one here.
Okay, Ms. Alstrom, go ahead.
Okay, thank you. Can you see my screen? Okay.
Yes.
So the first email is the one that Mr. Johnson referenced a moment ago, where Mr. Jackson is talking specifically about the protective order. The fact that Mr. Jackson is talking about the protective order and his understanding what it is isn't a document request, an inspection request, or discovery related to the lawsuit.
Well, it's an inquiry though, isn't it? I mean, it's clearly, a lot of these are, I mean, I think you skipped over the key word there, which is inquiries.
Well, it says inquiry and any other discovery related to his claim. So I guess the question is now, can he not make any inquiries at all?
That are related to the claims in this lawsuit, yes.
Well, then we have a problem, because number 2, for example.
Well, let me just say that he can still make a request. He just needs to go through his lawyer.
Well, and I do make requests as well directly to Mr. Johnson and Ms. Emerson. But I think maybe we probably need some guidance there on to the extent of inquiries, because again, Mr. Jackson actually has, if he's not already moved back into the building, is moving back into the building. So he is going to be there, and there are going to be, I mean, he's going to have inquiries. And now the question is it related to his lawsuit? Well, so let's look at Exhibit C here.
I mean, but let's just, I agree, there's some gray areas here, but
yeah.
I think it's a gray area if he's asking about the roof just generally. Like, hey, why don't we do something with the roof? I do agree that's kind of a gray area with this. But when he's making inquiries that are directly discussing the lawsuit and what are the claims in the lawsuit, what he's going to do, what orders he's going to obey, those are inquiries related to the lawsuit and clearly in violation of this order. And so maybe it does need to get a little bit clearer, but just based on what I've seen, there were a number of violations of this order. Now that being said, I don't agree with all of them. And I'm not sure what the right thing going forward is, if we need to everything to go through the attorneys, since he doesn't seem to be obeying court. I don't know. We'll have to figure that out, but.
And maybe we can, and I don't disagree. I mean, if it's related to the lawsuit, we've taken the position, if it's related to the lawsuit, then those inquiries, those requests need to go through my office, and I'll communicate them directly with, with opposing counsel. But the problem, and maybe, I think we've had a pretty good rapport between opposing counsel. Maybe we can kind of work through some of these things and come to a solution that maybe is a little bit more descriptive and what is included and what is not. But so with the issue with the roof, that is a continuing problem that he is going to have as long as the roof is not fixed. And I don't think that roof is going to be fixed, as far as I know, for maybe the next 6 months to a year, because the cost of it is going to be upwards of $700,000. So he's going to have inquiries. He's going to have, and if he makes an inquiry that's related to the roof, or is related to a repair that needs to be done, or the fact that he is suffering from another leak because there has been a heavy rain, certainly that inquiry can't go through my office, because that may be an emergency situation where they absolutely need to do.
I tend to agree with you if it's solely related to that, but if he starts, my concern is that, and this shouldn't be any surprise to you, Ms. Alstrom. I mean, you look like you seem like you've been in my court before, and you're experienced counsel, that you can't have conversations between clients represented clients about matters related to litigation has to go through the lawyers. And a lot of these communications are related to trial strategy, to the opinions about court orders, all sorts of stuff. That's clearly, I mean, even without an order, that would be a protective order, that would be in violation of the Texas rules. And so I just am not sure how we narrow the scope. I don't want it to be, anyway, this shouldn't be any surprise that this would be in violation.
Your Honor, and if I can briefly address that, I have no problem with him making maintenance requests directly to the management company. That's what they're there for. That's what, or if he has visitors coming and things like that, your normal operations of the building. Obviously, I think all of that, he could have the direct communications. He still lives there. He needs to deal with the management company on that. If he has a roof leak, this lawsuit is about roof leaks. It's about this roof. And so if he has a roof leak, then he needs to contact his counsel, immediately contact us, and we can get out there and with the parties.
I don't know why he would have to do that for a roof leak. I think you're being a little too restrictive there. I think it's hard because he'll intersperse things that I think are probably okay, which is like, hey, I have a roof leak. Can you do something about it? Or this is what you should do about the roof leak. So to me, what's clearly okay, hey, I have a roof leak. Can you do something about it? I think that's clearly okay. What's clearly not okay is, hey, we're going to take a much more aggressive approach in litigation and talk about the lawsuit and court orders and strategy and what orders he's going to obey and what orders he's not going to obey. Clearly not okay, and would be in violation of this order and just the rules. I mean, and so what the gray area to me is like this thing about the financing of the new roof and the $650,000 and the special assessment seems to be kind of a settlement discussion to me. I think that's maybe a little more gray. I'm not sure where I fall on that. But if you look at the continuum here, in my opinion, what my ruling is, I guess not my opinion, my ruling is anything on the clearly that needs to stop happening, or we're going to, take action. I think you should be able to contact them just about roof leaks and getting those repaired. And then we need to figure out something in between about dealing with these things that are quasi-settlement discussions. I'm not sure how to deal with those, and I'm not making a ruling on that. Does that make sense, Ms. Ahlstrom?
No, it does, Your Honor. And I don't disagree. That's the sort of the struggle we've had, is communicating what that gray area. And there seems to be an overlap within some of the emails that sort of touch on both. But
you as counsel need to advise your client that he is not allowed to discuss this litigation with the other side. That's your job, not his job. And if he wants to be self-represented, then I'm not suggesting he should at all. I think he's much better off with an attorney. But he needs to let you do your job. And a lot of the stuff he's doing here is clearly not okay.
Yes, and Your Honor, we absolutely take the position that anything related to the lawsuit has to go through our office, and I will communicate that again. And I don't have any issue with that.
Okay.
Absolutely, and candidly, it would be my preference.
No.
So I don't have a problem. It's the grayer area. So for example, and I don't want to take the court's too much time, but the discussion of the roof and the replacement of it and how possibly to fund that was in direct response to an open board meeting that was held and published, the minutes of it which were published, talking about the cost to replace the roof and the report. So, in that instance, clearly, yes.
That makes more sense. I can see that point. If it is a response to that.
Yeah, so some of these there will be a communication that goes out on behalf of the association. For example, it was the report that went out and how much it would cost to fix it, which then triggered a response of, well, yes, I would love if this roof would be fixed because it clearly, would benefit my client as well. And here are some ways to fund it. So yes, it sort of tangentially or does relate to the lawsuit, but does it violate the order where he's a homeowner? Like I said, I'm happy to try to work with Mr. Johnson and Ms. Emerson on how to maybe have something that's more detailed or a mechanism. And I think we tried to factor this into it to the extent that there was a communication that we thought would violate the order, that we added in sort of the conference requirement. So I am trying to think of a way that would be beneficial for all parties so we can maintain communication, but also not violate just the rules of procedure as well as any order for the court.
Do you guys feel like you have enough direction at this point to be able to craft an order, or is there anything else we need to discuss?
No, I think we're in good shape, Judge. I think there's obviously communications about counsel or to counsel or regarding the actual litigation or alleged, concealment of documents.
And let me just say one thing here that I think should clearly be in the order, is that there should be no direct communication, Ms. Ahlstrom, between your client and Mr. Johnson and Ms. Emerson. There should be no direct communication. That communication should go to you, and then you communicate to them. That's how it works in every case. That's how this should work. And Mr. Jackson is not allowed special rules. In this case, he doesn't get to be above the law. Nobody is above the law, and that's how this works.
And I don't have any problem with having that explicitly set out in whatever order going forward, so it's very clear for all the parties.
Okay.
I think we can work it out, Judge.
All right. Well, you guys try to work it out. If there's a big problem, I'm glad to have another status conference on this, but see if you can't get me an agreed order. And I'd highly urge you to Ms. Ahlstrom to run this by your clients. But also I don't want, Mr. Johnson, I don't want you guys to try to force him, if he has a problem with his roof and it's leaking, he needs to be able to communicate with the homeowner association directly to get that fixed.
Okay.
Your Honor, can I ask one more thing?
Sure.
Because you brought it up earlier, to the extent that we have an agreed order that the parties can present to the court, would we be able to have a brief hearing, perhaps where Mr. Jackson was present as well, just to make sure that
I think that'd be a very good idea.
Articulate. Okay. Then I'll get with opposing counsel and we'll schedule time and reach out to your coordinator about scheduling something briefly.
Okay.
Okay.
I could do it probably as early as this Friday or next Monday or the Friday after.
Okay. Perfect, Judge.
Okay.
Right. I appreciate it. Thank you, Your Honor.
You guys be safe. I hope everything's okay.
Okay. You too. Take
Thank
care.
you as
Good to see
well.
everyone.
Bye.
All right. Is everyone here on the Chauvin versus Singh case? Mr. Peters, what are you here for? No, you're here for that case.
I'm here for Mr. Chauvin, and I saw opposing counsel as well.
Ms. Collins and Ms. Rada, you were here for something as well?
Yes, Your Honor, it's the James Dodd matter. It's plaintiff's motion to sever and co-defendant's response.
You were a little bit early, so we're going to take this other case because that hearing's at 3:15, just FYI, not 3.
I apologize. Okay, thank you.
No worries. You can stay on. I just wanted to let you know.
Thank you.
All right. So let's go on the record. Tony, are you ready? On cause number 2010390, Chauvin versus Singh. Counsel, make your appearances.
Drew Peters for the plaintiff.
And my name is Stacy Collins. I'm here on behalf of the defendant, Sabita Singh.
Great. Let's go ahead and proceed.
Okay, Your Honor. This is a pretty simple car wreck case at an intersection. And we filed a motion to strike, originally a counter affidavit from a neuroradiologist, Dr. Davis. And then in the meantime, a couple additional counter affidavits were served on us. So we did supplement that motion. And part of it deals with another affidavit from Dr. Davis, but the argument's all the same. It's just two separate counter affidavits. And they're basically on the imaging provided to my client, the MRI imaging and other radiology. And what Dr. Davis does is he gives us some numbers that he says based on his experience and looking at certain sources, hey, this is the range. Like, for example, he says a non-contrast MRI ought to cost $400 to $1,200. And then he just picks the number in the middle and says, therefore, $800 is reasonable. And he doesn't give us any calculations, any basis, any of the underlying data he used, doesn't provide any of that. So basically, this is a situation where we contend that this is just the Ipsy Dixit of this doctor. The Supreme Court has stated clearly that the most credentialed expert doesn't therefore make them an expert on everything. They still have to provide a basis for their opinions. And so as to him, it's just real straightforward that he didn't provide any of his data, any of his reasoning. He basically just says, I'm a well-respected, well-credentialed neurologist, and therefore these are the numbers I think are correct.
And he's countering the MRI films, correct?
Correct, Your Honor. At MRI Centers of Texas, then the reading of the films by Uptown Radiology, and then his second affidavit was for Prime Imaging for a shoulder arthrogram.
Ms. Collins?
Your Honor, I'm assuming that we're not dealing with any sort of objection to timeliness or credentials of either one of the experts that we're here about today, because that's not mentioned in either one of these motions to strike. But if we go through Dr. Davis's affidavit, he is a board certified neuroradiologist, and he has been practicing in North Texas since 2007. His experience is one basis for his opinions because he does these procedures, MRIs, reading imaging. These are things that he does in his daily practice, but it's not, this affidavit is not just based on his experience or his education. He is very unambiguous about where he gets his data from. He's looking at Medicaid figures, Medicare figures. We detail this on a 3-page single-spaced affidavit where he's talking about calling other clinics, asking what their charges are, and looking at the competitors' pricing. This is all detailed in the affidavit. It's very unambiguous. He's basically just saying that they charge too much for the MRI, and that the reading of the MRI and the arthrogram, that those charges were too expensive also. And this is all very much, it's unambiguous, it's clear. And challenging these affidavits, I see that in this motion, as I see in a lot of these motions, that one of the arguments is that this is the whole purpose of 18.001 is to control costs for litigants. And I do agree with that, but it's for all litigants. It's not just for personal injury plaintiffs' attorneys to use this statute to hold us to this big standard of reasonable notice. It's obvious what his opinions are, and it's obvious what the basis for these opinions are. If this is not enough detail, then of course the remedy is cross-examination and asking questions about and tearing apart his basis if you don't like it. But if you're reading this affidavit, any person capable
Wait, how would you have cross-examination?
Pardon?
How would you have cross-examination on a counter affidavit?
Well, I mean, he can ask for a deposition. He hasn't done that. We have that happen all the time. And if you think that Dr. Davis isn't being fair about his opinions or the basis for them, then ask him about that. He has using fair health data. He's using Medicare data, Medicaid data, workers' compensation reimbursements. So
let me just tell you how I handle these. Pretty much the same on every single case. I try to be extremely consistent. Folks don't always agree with me, but this is how I deal with them. And I want to be consistent across the board, which is this doesn't apply here, but I always strike billing clerks. So anybody who's not a medical provider, like we see a lot of these auditors or whatever, I always strike those folks. And so then I look at the area of specialty. Are they countering the same area of specialty? Do you have a chiropractor countering a chiropractor, an orthopedic surgeon countering an orthopedic surgeon? That seems to be okay here, at least for the neuroradiologist. So then the real question becomes, and then the next thing is I don't allow comparisons to Medicare, Medicaid, workers' comp. Those are totally different systems. They're apples and oranges. I don't think they're relevant at all. And so the main issue comes in is he compares this to Medicare, Medicaid, and workers' comp. So for that portion, I would probably strike. But he does say he contacts other providers, I guess. Is that right?
Yes, sir. He actually says in section 10, I use cash payment as a basis for comparison on what a patient might pay. That value can give an idea as to what other imaging centers would accept. He goes through, in detail here, he's giving a baseline range, and the amount that he actually estimates for the charges that he thought would be reasonable under these circumstances are, I think, 800 times the Medicaid approved rate. So he's very specific about where he's calling in network health insurers to see what they're charging for these same procedures, and arriving at an opinion that the prices that are being quoted in the affidavits that the plaintiff has filed are high. And all I'm saying is I understand they don't agree with what my doctor's saying, but he is giving them fair notice, and he is qualified to testify about these things in an affidavit or a deposition or in person. And, fair notice, it doesn't require us to try our entire case in an affidavit of one doctor. It's just not ambiguous what his opinions are. He has looked at these charges and compared them in the very area where he works, the physical geographic area where he works, and he's saying that they're too high. And again, I don't guess I have to address his qualifications. He is a neuroradiologist that's board certified, but excluding this evidence that's not the proper remedy.
I think there's a bit of a misunderstanding here, which is I'm not ruling today on whether or not this doctor can testify at trial. I'm ruling on whether or not this counter affidavit will be allowed to stand so that it counters the essentially is the plaintiff going to have to call their neuroradiologist live at trial. I just want to make sure that's clear.
Yes, Your Honor. And can I respond briefly?
Sure.
I think we're all on the same page that the doctor certainly does unambiguously provide his conclusion. He also provides his sources, alleged sources, but he provides zero data, no underlying reasoned basis, how he got to these conclusions. The analytical gap is completely missing. He provides an outline of his methodology, but not the actual, he doesn't show his work, so to speak. He doesn't do any calculations or show us what numbers he found. And also, I don't see anywhere where he says he called providers in this affidavit. And if that's
I think it says that.
It does. And I guess maybe there's the difference in how we read this statute and what would be fair to all litigants, because, he provides his opinions, he provides his experience, he provides the data that he's looking at. And if there's any sort of questioning between how he gets from one point to the other, when he has provided a ton of information here, again, that's what I'm saying, judges. This is where if you think that he's not connecting the dots with as much detail as you want him to, then notice up his deposition and ask him the questions. If he's incapable of doing it at that point, then obviously it's not valid. But what is in this affidavit gives reasonable notice of what his opinions are. And what is in this affidavit gives reasonable notice of what his bases are for finding those opinions. It's not confusing at all. He delineates exactly what he's relying on. It's just a matter of, I get it. They want more information from me. My point is we have met the minimum standard that Texas requires us to meet.
And I disagree, Your Honor. Obviously, I need that info to decide whether or not I want to depose the doctor. And the information, this data, the underlying data that he reviews, prepares, et cetera, should be provided pursuant to a disclosure. So it hasn't been provided, period, with this affidavit or in the disclosure.
Where, I guess maybe I'm wrong. Where does it say that he called other providers? Maybe I'm missing that. What
I did
paragraph?
a control find and can't find it, Your Honor. Control
In
F.
his report.
Oh, is it in the, not at the affidavit, the report?
Let me read through it and find it.
It says, I also make comparisons with amount I determined to be reasonable charges for the CPT code through research with the same company, charge allowed by discount payers for CPT codes, such as in-network health insurance, as well as the ones listed below. Is that what you're talking about, or is it something else?
Yes, Your Honor. And in fairness, I recently submitted him for a deposition. It's possible that he actually made that statement in his deposition. I know that's his practice, is to call these facilities on a regular basis and see if their numbers have changed, or if everybody's still basically in the same ballpark on charges for these types of procedures and for interpreting the films.
So you said there were two affidavits or two doctors that were, there's Davis and who else?
Burkhead's the other one.
What is Burkhead? Is he a chiro?
He's an orthopedic surgeon.
Orthopedic surgeon, okay.
Yes, Your Honor.
What's the basis for striking him?
He similarly kind of baldly asserts that the treatment isn't reasonable or necessary. But then in paragraph 9 of his affidavit, as is outlined in our motion to strike, he actually says the services are reasonable and necessary, but they weren't a result of the accident. In other words, he's addressing causation, which was never allowed and is specifically per the
So
statute.
I'm trying to look here. What I remember reading about the neuroradiologist. Where is the motion to strike this doctor or this affidavit?
The
Why
one
don't you, let me do this. Why don't you share screen it so I can take a look at it?
the you're referring to Dr. Burkhead, Your Honor?
Yeah,
Okay.
just the report.
The report, not the counter affidavit?
Either.
Okay.
Are we moving on to Burkhead?
Yeah, for now.
Okay.
We're just asking to share screen that one because I can't find it. Or let me just ask this, Ms. Collins, do you agree that your doctor is really just challenging causation in this counter affidavit?
I do not agree. I think that he's challenging the necessity of any of the treatment that this plaintiff had at North Texas Orthopedic and Spine on the basis that this particular injury, so it's a left shoulder injury, that there was no new injury at all based upon the imaging that this doctor had seen. That there's no evidence that there's a new injury at all. So all of the treatment and proposed treatment at North Texas Orthopedic and Spine would be, in this doctor's opinion.
I disagree with you reading this. I'm going to strike this affidavit. All right, so let's go back to the neuroradiologist. There's a couple ways I handle these. I don't know if either of you have been in my court before when I talk about this, but I kind of do it the same way every time. My interns have already heard this speech a number of times. Is you can, I can rule on it and either grant or deny the motion to strike, or we could do dueling affidavits. Are you guys familiar with dueling affidavits?
Yes, Your Honor.
Ms. Collins?
I'm not.
Okay. So what dueling affidavits are, just a little background about me, Ms. Collins. I don't know that you've been in my court before. I'm a former personal injury attorney. This is the kind of cases I used to try when I was in private practice. So I kind of adopted this practice that I think a lot of other judges do in Dallas and have been for quite some time. And that is, if I don't strike this affidavit, then the plaintiff would be required to call the doctors alive. And if I do strike it, then you're not allowed to contest reasonableness and necessity. And so what dueling affidavits is kind of a middle ground, which says, okay, look, the plaintiffs are going to be allowed to prove these medicals up via affidavit, but the defendants are going to be able to submit the counter affidavit at trial as an exhibit so that they can argue it at closing. And about, I don't know, half to 2/3 of the defense attorneys in town, I don't know what you think, Mr. Peters, but I see these quite a bit, will agree to it, but some don't. So does that make sense, Ms. Collins?
It does make sense. Are you asking me if I agree to it?
Yeah, I only do them if they're agreed to.
I would agree to that.
Mr. Peters?
I typically like to make that decision closer to trial. It has to be made today.
It's up to Ms. Collins.
I mean, I guess, we don't even really have a trial setting or not a valid trial setting at any rate at this point in time. But I mean, I'd like to know at some point if we're going to be revisiting this or if I'm going to have this hanging out there.
Oh, let me ask a question. You guys have a valid trial setting. It's just not until 2022.
Okay.
Mr. Peters, if she wants me to make a decision today, I think it's only fair for her to do that. If she's willing to agree, then I'd say the vast majority of plaintiffs' lawyers I know agree to it, but not all of them. So if you want to agree, you can agree. If you don't want to agree and she's willing to wait to make a decision, for me to make a decision, I'm willing to do that. But if she's not, I think it's perfectly fair for her to not agree, and I'd have to make a decision today.
Yes, Your Honor.
So Ms. Collins, what do you prefer?
Yeah, Stacey, we can push it till after mediation too. Might make sense.
Yeah, I was going to say 30 days. I mean, do we have a mediation scheduled?
We do next month.
Okay.
What I would suggest, Ms. Collins, if this is okay with you, is that what I would suggest is that we go ahead and if you guys agree, then enter into a Rule 11 agreement and submit it to the court after mediation. If you don't agree, then send me a letter and saying, Judge, you need to make a decision on this and present to me opposing orders on this. If that's okay with you, Ms. Collins and Mr. Peters.
I think, sure, that sounds fair.
Yes, that sounds great, Your Honor.
And then for the other one, did you already submit an order for the one I struck?
We did, but it would be combined with Dr. Davis.
So why don't you submit a new order, run it by Ms. Collins, and then email it to my court coordinator as well as e-filing it.
Yes, Your Honor.
And make it clear in the email to her that I've already ruled on this.
Okay.
And include today's date in the, like it says on this date, put on February 22nd, 2021.
Yes, Your Honor.
Does that make sense?
Yes, absolutely. Don't leave it blank for you to fill in.
Yeah, well, just it helps me remember when I ruled on this, because I have hundreds of hearings, and so and remotely it just gets to be difficult. So if you would just put in there the date so I can go back and look at it when I get it.
Absolutely.
All right. Thank you, Ms. Collins. Nice to meet you. Mr. Peters, good to see you again.
Nice to meet you.
Good to
see
see
you
you.
guys.
Nice to meet you too, Drew.
All right. You guys have a great day, okay?
Bye. Thanks, Judge.
Take care.
Okay, do we have both sides here on the Dodd v. the heirs or legal representatives of the estate of Tony Matthews?
Yes, Your Honor. Stephen Bega for the defense.
Ms. Rada, are you here for that?
Yes, Your Honor, I'm here for the defendant, the estate of Tony Matthews.
Mr. Lee, Mr. Mandeville, are you here for something else?
Steve, you have to
can't
unmute.
Mr. Lee, Mr. Mandeville, if you guys want to unmute.
Yep, thank you. Judge Kyle Mandeville here on behalf of Defendant Driver Resource.
Mr. Lee, what are you here for?
I'm here on I'm here for the Dodd matter. I represent the plaintiff, Mr. Dodd.
Okay. Tony, let's go on the record on cause number DC 199372, Dodd v. the heirs or legal representatives of the estate of Tony Matthews et al. Counsel, make your appearances.
Stephen Lee for the plaintiff, James Dodd. We're ready.
Stephen Bega for the defendant, the Empire Company. And not as to this motion, Your Honor, but we also represent Penske Truck Leasing and also CF Motor Vehicle Leases.
Great.
Ben Rada on behalf of the estate of Tony Matthews.
Okay.
Kyle Mandeville of the Passman Jones firm here on behalf of Defendant Driver Resource Company.
Okay. Is that everyone?
Yes, Your Honor.
I think so, Judge.
Let's proceed.
Judge, this is a motion to sever that's filed in this lawsuit that's been pending since July 2nd of 2019. It's a plain vanilla, for the most part, negligence, gross negligence lawsuit against various entities arising out of a motor vehicle accident involving a tractor trailer. That's why we have so many defendants, because we have a tractor and a trailer and leasing agreements.
Okay.
Almost 2 years after the lawsuit was filed, Empire filed a cross-claim against Driver Resource, alleging allegations of breach of contract. Now, it seems like Empire is suggesting there are multiple claims. I think they're saying there's a breach of contract claim, there's a claim for contribution, and there's a claim for indemnification. But really, all those claims arise out of contract. They all sound in contract. And just to get this off the table, the contribution claim is a red flag because there's going to be a contribution question in this case per Chapter 33. So really, this claim and cross-claim and extra claim that has been filed by now Driver Resources against Empire to complicate matters even further now doesn't have anything to do with contribution. We all know that in the charge, there's going to be a contribution question. So we filed this motion to sever because we believe the contractual claims asserted by Empire against Driver Resources and now Driver Resources against Empire should be properly severed from the underlying tort claims. Texas law, a claim is properly severed when 1, the controversy involves more than one cause of action. 2, the severed claim is the proper subject of an independent lawsuit. And 3, the severed claim is not so interwoven with the primary action that they involve the same facts and issues. That's the Texas Supreme Court. That's the law, black letter. In this present case, it's pretty clear that Empire has conceded that there's more than one claim or cause of action. You've got a tort claim and a contract claim. I think they're conceding that. They're also conceding reasonably that the contract claim is a proper subject of an independent lawsuit. Certainly, Empire could have just sued Driver Resources independently. And my suggestion would have been that they waited, and I'll tell you why in a minute, because there's law that says it's not that the claim by Empire and by Driver Resources against each other, the cross claims, are not ripe yet. But really, the only issue is whether the claims are interwoven. And so, whether the contract claim and this personal injury claim are interwoven. Well, I'm going to suggest to the court that they're not even close to being interwoven. The parties are not identical. You've got cross claims between Empire and Driver Resources for breach of contract, contractual indemnification, and those are the only two parties to those contracts. Series of contracts that were entered years ago, well before this crash. It doesn't involve the plaintiff, Tony Matthews, Penske, or CF Motors. So it doesn't involve 2/3 of the parties in this claim who are going to have to sit through and be involved with any discovery and any examination of witnesses and examination of documents. So 2/3 of the parties to these claims are going to have to be involved with them when there's no need for it. Importantly, too, though, the duties are different. With the tort claim, you have duties of what the public has as an obligation under statute and common law. With the breach of contract claims, you got duties between just these two parties based on contract law and per the contracts that are involved. So there's certainly a concern when you start looking at the proportionate responsibility question that's going to be submitted in this case, that the jury is going to get confused about responsibility and whose responsibility they should be comparing. And that's a significant issue. Also, this is not a compulsory cross claim between these parties. These are permissive cross claims. Now we ask you, are the claims involving the same facts? They don't involve the same facts. The personal injury claim involves facts focused on the underlying suit and what led up to the crash. The contract claims involve 3 separate contracts. I think they were entered in like 2011, 2013, 2017 between just these two parties, Empire and DRC, Driver Resources. Then the question is, and the next one is whether the witnesses are going to be the same. They're not. This personal injury claim that I have filed is going to involve witnesses to the crash and to the events leading up to the crash. This contract claim that these two parties are disputing are going to involve completely different legal issues and factual issues. There's going to have to be a prove up the contract. There's going to have to be some prove up of the application of the contract to the situation. There's going to have to be a prove up of the interpretation of the contract. And there's going to have to be a prove up of the defenses that are being asserted by each one of these parties against each other. And so those are completely different issues. And we're going to have a whole host of different witnesses that nobody's even thought about. In fact, Empire and DRC have not identified a single witness that's going to be prepared to testify about interpretation of these contracts. They have not done that. And what's important about that is our fact evidence ended January 25th of 21. So I'm not quite sure how that's going to play out. But again, there's been absolutely no identification by either one of these parties in this cross action as to who's going to testify about interpreting the contract, its application, and its construction. You're also going to have nearly 100 pages of extra documents that have nothing to do with the underlying crash. And you're going to have probably several dozen pages of documents, defensive documents, because there are going to be demands and notices and the things that need to be given to each other pursuant to these 3 contracts that I don't know if any of the parties have read completely. And finally, Judge, and importantly, I don't believe that the indemnity claim is mature yet. It's not ripe. There's a Texas Supreme Court case, Ingersoll versus Rand Company. Ingersoll Rand Company versus Valero, 997-203, Texas Supreme Court, 1999. I have a copy of it that I sent over to the court. It specifically says that these contractual indemnity claims do not accrue until all the indemnities, liabilities become fixed and certain. And so the point of that is really neither one of these parties, Empire or DRC, know what their damages are because the underlying claim, this personal injury lawsuit, hasn't been resolved. So number one, the reason there's no reason to do this is because these parties don't know what their damages are. And number two, there's a possibility that they may never need to fight this fight, and the court never needs to hear this, ever. So there's some judicial economy involved in not having these contractual claims thrown into this negligence claim. Also, there's some concerns about some prejudicial evidence coming in, because a lot of these claims between these parties involve insurance and the application of insurance. And there's also some concerns about demands that have not been developed. So, Judge, our argument is this contract claim, these breach of contract claims that have been filed between Empire and DRC, Driver Resources, should be severed. There's certainly a potential for some real confusion with regard to the proportionate responsibility question.
Mr. Lee, I get it. I do notice that when the order was submitted on this, it said an agreed order of severance. Is this agreed to?
It's not, Judge. If my order says agreed, it's an accident. It's a mistake.
Okay. Be careful about that, because sometimes I'll sign those because I think they're agreed to, and then.
Yeah, if you did, I would have sent it back to you and said we have no agreement. I apologize for that. So
Okay.
It's not agreed.
Response?
Sure, Your Honor. And again, Stephen Bega for the Empire.
Go ahead.
Sure. And again, Stephen Bega, the attorney for the Empire Company. There's actually a couple of things that I can concede and agree with Mr. Lee on. And first of all, I can agree with him that in terms of the standard, the legal standard you have to look at, more than one cause of action, independent claim, I agree that there's no issue there with respect to those parts of the elements of this particular severance claim or motion. However, the third one has to be not so interwoven with the remaining action that it involves the same facts and issues. I completely disagree with him on that. And notice that when you're looking at the elements of this particular motion for severance, it doesn't say that has to involve the same cause of action. It just says the same facts and issues. And that's important because when you're looking at the allegations that plaintiff is making with respect to negligent hiring, negligent entrustment claims versus both Empire and the Driver's Resource Company, it is very similar. In fact, it's very close to being verbatim with what the contractual terms are between Empire Company and Driver's Resource Company. Just in general, what the plaintiff is alleging is Tony Matthews, the driver involved in this particular accident, was not safe, he was not competent, and then also he was not qualified under the federal and state regulations. If you look at the contract between Driver's Resource and Empire, those are the exact duties, those are the exact terms and conditions that is outlined in that contract, meaning Driver's Resource had a duty under that contract to provide a safe, qualified under the DOT regs, and also a competent driver. So when you're looking at the facts and the issues, they are the same. The facts are the same. And I want to approach this looking at this from the plaintiff's perspective. In order for him to prove that Driver Resource was negligent, he has to establish that there was a duty. In order for him to establish a duty, he has to show this contractual terms and agreement that they made with respect to providing Tony Matthews as a safe, competent, and qualified driver. He's going to already be introducing terms of that contract. Further, he's going to have to present facts and evidence of how Tony Matthews was an unsafe, incompetent, and unqualified driver. So all of the facts to both his negligence and gross negligent claim and our breach of contract claims are the same. In order for us to properly defend this suit, I've got to be able to show a jury the contractual relationship between Driver Resource and Empire Company and exactly what Driver Resource agreed to provide with respect to this temporary driver. So when you're looking at the issue that the jury is going to have to determine, it's whether or not, based on Tony Matthews' background, his driving history, his criminal history, his experience, etc., was whether or not Tony Matthews was a safe, competent, and qualified driver under the DOT regulations. If you compare what the plaintiff has to prove up compared to what Empire has to prove up with respect to that breach of contract claim, they are the same. So, we have a case where, first of all, I do want to say it's not our position, and we are not conceding that Tony Matthews was not a safe, qualified, or competent driver. But this is very similar to a construction defect case, Your Honor, and I'm sure you've had some of those in your court before, where the owner sues the general contractor for negligence, but then also the general contractor turns around and sues all the subs for breach of contract. In those situations, those claims are never severed from the underlying lawsuit. Those claims are always presented to the same jury at the same trial. So, what we've got here is a similar situation. Now, yes, he's right. There are claims for contribution, which I'm arguing shouldn't be severed because he's right. They are going to be on the line in the jury question to begin with, the comparative responsibility. In terms of the indemnification issue, I kind of actually agree with him too. Those aren't right. I would be perfectly fine setting aside any sort of indemnification issues for later. But this breach of contract claim, Your Honor, is so vital to the defense of Empire in this particular case. It involves the same facts, the same issues that a jury has to consider. So yes, when we're dealing with things such as judicial economy, it makes sense. Empire and Driver Resource are both parties. Empire and Driver Resource are both going to be present at trial. Empire and Driver Resource are going to have witnesses explaining the duties under that contract. Whether or not the breach of contract claim is here or not, that's something that they're going to have to do regardless. Also, there's going to be argument by both Driver Resource and Empire's lawyers as to the application of that contract to the duties that are established in this particular case. So when you're talking about judicial economy, we're already doing all of those things that we would have to then turn around and do a second time. That doesn't make judicial economy sense. To have to waste this court's time on a second trial, going over the same witnesses, the same facts, the same arguments, and having to impanel a second jury to do that. This is not going to confuse a jury, Your Honor. In essence, when they're comparing responsibility, that's what they're doing anyway. They're determining, did Driver Resource have an obligation under that contract to provide a safe, qualified, and competent driver? And if so, did they do that? So that's something that they're already going to be doing. Adding an additional breach of contract claim doesn't add much to that. In terms of this argument about there being a whole host of other witnesses and so forth, I've already designated Empire Company's corporate representatives as people who are going to testify in this case. That's all I need to prove up that contract. That's all I need to explain the terms and duties. I don't need an expert to come in and explain and interpret these particular contracts. And I would say that Driver's Resource would say the same thing. They don't need experts to come and prove up their case anyway. So with all due respect to Mr. Lee, we have our trial to try, and we're going to do that. And so just because, we may not have, to his satisfaction, designated experts or testimony and so forth, that's not really his bridge to cross. That's between Kyle Mandeville and Driver Resource and Empire, not him. But again, looking at it, in this particular sense, they do involve the same facts and the same evidence. All you have to do is look at the plaintiff's petition. It's the First Amendment petition at this point. He doesn't even separate specific claims that are alleged against Empire and Driver's Resource. For example, he doesn't say Empire is negligent because of this, and then he doesn't, in different paragraphs, say Driver Resource is negligent because of this. He lumps them together. He says Empire and Driver's Resource are responsible for these things. He says Empire and Driver's Resource failed to do these particular actions. And again, those are all actions that are outlined in that contract. So they do involve the same facts. They do involve the same issues. The other,
well, let me ask a question here. Would it make sense to bifurcate these and try them with the same jury, but in two phases? Or would you guys be able to get that ready, or would that not make sense?
Well, I just think that, when you're having a jury already hearing testimony, well, here's why I don't think it makes sense. Only because, again, in order for us to say we met our duties on some of the DOT regulations, we're going to have to say that we contracted with Driver Resource in order to do some of these things. And so when you say bifurcate trial, does that mean that I can't, in the first trial, introduce evidence of that contract? Does it mean that I can't raise arguments about that particular contract and how Driver's Resource may or may not have breached it? I don't think that that makes sense. And in fact, I think that is very prejudicial to us to not be able to do that. Now, all those questions about insurance, he's right. There is a provision in there in the contract that says Driver Resource is supposed to provide insurance on this particular case. And, there are ways that we can work around that, because really, that's not the main beef with that contract. It's whether or not they had a duty to provide a safe, qualified driver. The insurance issues, I would lump them in with indemnification issues. Those are things that can be held for another trial, that can be separated out and argued, like Mr. Lee said, if necessary, at a later time. But again, this jury is going to be listening to the terms of this contract already. They're going to be hearing from us and from Driver Resource about the defenses to those particular issues. So I don't think it makes any sense to separate this and to sever it out when the facts and issues are interwoven. Just because one is contract and one's a negligence cause of action, that's not the test that the court has to look at. And so I think all of those reasons show how we would be, Empire Company would be prejudiced by not having the ability to make those arguments and to assert that particular breach of contract claim.
Judge, may I respond?
You may.
Judge, that he's almost put his finger on it exactly. If there's going to have to be a workaround, that's a problem. This is a simple negligence case involving an automobile crash. The problem is once you start giving different standards to the jury with regard to all the parties versus two of the parties, the jury's going to have some real problems understanding this. The DOT regulations and the traffic code violations and the criminal code violations that are applicable in this case are what sets the standard of conduct and obligations and duties for the parties in the underlying crash. Those differ significantly from the obligations and duties pursuant to the contract between these two parties. We never have to talk about these contracts, ever. The easiest thing for them to do is that it's clear that there was an agreement between the two, Empire and DRC, about the hiring of Tony Matthews, and then they decide which way they're going to argue between themselves about their obligations, but they don't have to talk about the contract. If you bring in the contract, all of a sudden, we're going to have to listen to additional witnesses, fact witnesses about the application of the contract, the terms of the contract. There are going to be additional issues with regard to indemnification, about construction of the contract. You have three separate contracts, so there's going to have to be a discussion about which is the controlling contract and whether there's any overlap and whether there's any issues concerning.
Okay. All right. So I'm going to go ahead and grant the motion for severance. I do want to point out, I looked at the order on this, and this may be the way they do it in Travis County, but I've rewritten part of your order to comply with what we do in Dallas. You're going to have to pay a severance fee, Mr. Lee, in order to do that. There's some Supreme Court case law that came out relatively recently that says that it said that unless I include in the order that the payment of the severance fee or the severance is conditioned upon the payment of the severance fee, then it's not required to pay the severance fee. Clearly, Dallas County requires the severance fee, and so I've included. It's a little hard to read, but I'll just read it so you can see it on YouTube. This order shall not become effective until the plaintiff pays the severance fee as set by the Dallas County District Clerk and the assignment of a new cause number. And then the cause number would not be. You wanted to split it up so it would be 19.9372A and 72B. That's not how they do it in Dallas County. They assign a whole new cause number. So anyway, I just wanted to kind of explain that to you.
Yeah, I'm writing notes, Judge, but I've got that.
Okay, so it's in the order, but my handwriting's not very good. So I just want to make sure that you have that. But again, this will not become effective unless you pay a severance fee. I did have a question about the trial setting. It's on April 27th. You know, I know in Travis County, they're trying a small number of remote jury trials. I actually tried one remote jury trial since COVID started. I don't know how many. I don't know that this case would be appropriate for that if we start doing remote jury trials again. But what do you guys want to do? We can keep this on April 27th and just see what happens. I could put it on a remote trial docket if we end up continuing to do remote trials, or we can continue it, or we can address this later. I just want to kind of raise the issue.
I think we have, Judge, I doubt that this is a case that we can try remotely. I think it's
That's fine.
we've got too many parties and too many witnesses and too many ways to bungle the evidence. And I'm the first one to say electronically, I'm a bit challenged. But we have a mediation, I guess, coming up here in 30 days, I think. Maybe we should wait to see if that gives us anything before we make this decision, because my experience is if there's no fire under the burner, the water's not going to be boiling, so nothing's going to get done.
Let me say one other thing, Mr. Lee, just so you, because I know you're not from Austin. I don't know if these other attorneys are familiar with this. And again, guessing the what's going to happen with this pandemic is, has been a losing game for me since I started. But we do have a provision in place. I don't know if Travis County has this, where we have threat levels for COVID. So Dallas County is currently in a red threat level. They've been pretty much in a red threat level 95% of the time since this started. But if it drops to an orange threat level, then we do have the ability to do what's called a hybrid trial. The hybrid trial means that the jury selection would be remote, and then the rest of the trial would be in person. And that is something that is possible that could happen by April. So just kind of be aware of that, and I would require you to do that. I think that jury selection, I've done jury selection online, and it's not ideal, but it's doable more so than the rest of the trial. And so the April setting is unlikely, but it is possible because we could have a hybrid trial. So just kind of be aware of that. I'm not making any decisions. I'm not requiring you to make any decisions, but just kind of have that in your back of your mind. Do you have any questions, guys?
I was just on this last issue. If you were a soothsayer and you were saying, hey guys, get a trial setting, another trial setting, how far would you set that out, Judge?
I've been so bad. I have been so bad at that. So let me tell you what I'm generally doing, and I'm not saying I would do it for this case, but generally what I'm doing is for 2017 and 2018 cases, I'm setting them in the fall, and for 2019 and 2020 cases, I'm setting them in the spring. That's kind of what I'm doing. And just to try to give you a somewhat reasonable trial setting, at least you'd have some possibility of going on. But I'm sure it's the same way in Travis County. We are so backed up at this point. We're almost a year without jury trials. I don't know when we're ever going to catch up, but that's kind of what we're doing right now. Again, that doesn't take into account the whole issue of hybrid trials and if we actually ever do those. So
you don't have a mixed docket, do you, Judge? You don't do criminal?
I do not. I'm all civil.
Okay.
So that is an advantage over certain other counties. I don't have to worry about, this criminal trial or the CPS trial. We're all civil.
Okay, thank you, Judge.
It sounds like the consensus is that you want to just wait. Is that right?
Well, my only concern, Judge, is that plaintiff has designated about 5 or 6 experts. We're planning to designate, just us and other defendants combined, probably 6 to 7 other experts.
Okay.
Expert deposition deadline of like March 27th or something like that. So it's going to require us to do a whole bunch of work.
I know how much you guys love billable hours, though, so I'm kind of doing you a favor.
I'm not sure what the problem is. I guess it's because my work's all done. I've done it now. Like, hey, now let's see if we can just take a breather.
I'm sorry, Mr. Vega. I was just kidding. Go ahead.
No, I mean, I didn't want to interrupt, while you're making all that. I'm still wishing that I could still reply to what he said on that motion for severance, or if that's under the bridge.
Okay.
Only because here's my concern. I mean, because this leads to questions about whether or not, at the time of trial, whether counsel for driver resource and I can even broach the subject of these contracts. I mean, that is so significant a part of the defense for both parties, frankly, that by severing out, I mean, again, you're hearing all of these things. He talks about that the standard is different of the DOT regulations. And then also the contract. The contract requires them to provide a safe and qualified driver under the DOT regulations. They're the same. So, I mean, again, my concern is that we're already going to be arguing these things. And by severing out, my new concern is that now I'm going to be somehow prohibited, or driver's resource is going to be somehow prohibited.
I'm not making a ruling. I just want to make it clear, there's nothing in the order. I'm not making a ruling one way or the other, because I'm sure this will be brought up at some point about whether or not you can. He says he doesn't want to have to go into the contracts. I'm not making a ruling about that. If it's relevant information that's necessary for this tort case, then I will be, then it's going to come in, just like it would be in a right to control on a premises liability case for involving an independent contractor. The contracts come in. I'm not saying that that's not going to come in. It may come in. I don't know, but I'm severing.
Right,
So
but you certainly understand my concern about that. And the fact that, it's not just the indemnity claim that I agree with him should be severed out, but, again, this breach of contract claim, I just don't, to me, that's the definition.
I respect that sometimes attorneys don't agree with my orders, and I apologize that you don't agree with this one, but I have ruled. And so one of the things I was told as a new judge, and I've tried to do these last 15 years, is to rule. And so.
No, understood. I just understood. I just wanted an opportunity to, since he got to respond to what I said, I wanted to be able to at least make those points. And if it made it great,
and I hope that
I live with it.
I hope that my clarification gives you some solace. But do you want to stick with this trial setting for now and just kind of see what happens, or what do you want to do, guys?
I mean, personally, I don't think it's realistic, because we've had a very hard time even coming to an agreement on dates for this hearing, even coming on agreements for the other fact witnesses. And whenever you get 4 or 5 parties to basically say, okay, now let's set dates for 10 to 15 depositions in the next month. You're right. I love billables as much as anyone else. And I don't care if that's on the record, but.
No, I was just teasing you guys.
I don't think that that's doable, to be honest. And I know. And
what I would suggest then is if there's, I was wondering if you had an agreement. So I have a lot of cases these days, the parties, because of all the difficulties, have an agreement. They say, look, we think we should move it. If you don't have an agreement, then file a motion for continuance and explain all of this, and I'll rule on it then. I was just trying to see if, I don't know this case as well as you do, obviously. And so if it was a situation where everybody agrees, hey, that date is not realistic, we want to move it, then I just wanted to kind of let you know. But if it's not agreed to, then you have to go through the normal process.
Your Honor, Lynn Rada here. Our mediation is March 12th in this matter, and I would agree with Mr. Vega. Let's go to mediation. We're set for it. I think it's the best idea we have in this case. But certainly after March 12th, if this case doesn't settle at mediation, we will need a new trial setting. That's my opinion.
I'm happy to discuss that and look at the timeline and all that stuff to see if that's appropriate. I think it's fairly unlikely we're going to have jury trials on that date anyway, but it's not impossible. We could have hybrid trials. I don't think that we'll have fully in-person trials by then, but it's theoretically possible. And so, but if there's not an agreement, then you have to go through the normal process. So I'm happy to do that. All right, guys, you guys have a good day, and you guys be safe. All right.
All
right. Thank you.
You may.
Thank you.
I think our next case is Canterbury Co. versus the THB Construction LLC. Is that right?
Yes, Your Honor. This is Eric Calhoun on behalf of the plaintiff, Canterbury Co. Thank you.
I'm going to need 3 minutes.
Okay, Tony needs 3 minutes, so let's take a quick break, and I'll turn